Welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All.
Hello and welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All with Eric L. Pines. Eric is a nationally recognized federal employment lawyer, mediator, and attorney business coach. He represents federal employees and has been in-house counsel for over 50,000 federal employees through his work as a federal employee labor union representative. I'm Chelsea Reynolds, and today we're discussing when it might be time to stop pushing for accommodations and instead pursue a disability retirement claim. This is episode 21, From Accommodation to Disability. Welcome back again, Eric.
Thank you. It's great to be back. Good to talk to you, Chelsea.
How does somebody know when their accommodation efforts just aren't working anymore?
Okay, so there's so many different ways to answer that question. But I want to point out that is kind of like the crux. The answer to that question is the crux of how we built our law firm, because we pride ourselves on being the attorneys who can help you get that accommodation. And that usually relates to assisting you with the reasonable accommodation process. It also relates to filing a lawsuit for failure to accommodate with the EEOC, the EEO office, if that's necessary, which would be the next step if they didn't accommodate you. And then at some point, if your condition becomes so bad that you cannot, which is kind of what you're asking, that you can no longer work, we can assist you with disability retirement for federal employees, which we call OPM, because it's OPM who makes the decision, Office Personnel Management, and Social Security Disability, which you have to apply for in order to apply for OPM. So that's the big picture. But to answer your question specifically, you know when your accommodation efforts aren't working, when it's clear that the agency is not giving you the accommodation that you need. And the legal word for that, the term of art, is an effective accommodation. So if the agency comes back to you, now the agency, this is pretty interesting. The agency does not have to give you the accommodation that you requested. And they do not even have to give you an accommodation that you like, but they must give you an accommodation that's effective. And effective means it allows you to do the essential functions of your job with that accommodation. So if you can make the colorable argument, sorry to be too legalistic there, if you can make a good argument that, and when I say you, I mean really your doctor supporting you, if an argument can be made with your doctor's support that the accommodation that they're offering to you is not effective, well, and they're not still engaging you in that interactive process, or it's taking forever, I mean, months and months and months, at that point, they aren't working anymore, and you either have to file an EEO case for failure to accommodate or seek disability retirement, because in some ways they're setting you up for disability retirement, because one of the questions that OPM wants to know is, did you request accommodation? And you have to be able to answer that you did and that they were unable to accommodate you. Or that there's no, I should say the other possibility is that you're so ill that there's no accommodation possible.
Those sound like some good markers or flags, like, oh, it's been a few months. What are some other red flags that indicate an agency isn't acting in good faith?
Long delays, switching people who are speaking to you. So a lot of times agencies call them reasonable accommodation coordinators, or LRACs. You can tell their emails are vague. They come months apart. A straight rejection, of course, would be a red flag. We're not going to accommodate you. So the grayer area is when they do respond and they do seem to be engaging you in the interactive process, which means there's a back and forth to try and find an effective accommodation. But it's clear that they're not going to accommodate you and they're just playing the game. So most people, that's the triggering thing that gets them to reach out to an attorney like ourselves, is when they reach a point where they no longer feel like the agency is taking them serious. So the red flags are there, but I think some of it's intuitive, where you can tell that they're just playing you and they're not serious.
And if you push too hard yourself, if you're pushing too hard for accommodations, can that actually hurt your disability retirement claim?
I don't think so. I'll tell you why. Because OPM wants to know that you pushed hard for accommodations, because they don't want to give disability benefits to anybody who could be accommodated, because then they don't qualify. So you might be able to push too hard and annoy your supervisor and have them write bad things about you on your performance appraisals and have them become your enemy, which nobody wants, and most of my cases are based on that. But I don't think you can push too hard as far as the disability retirement aspect. That one, I think you should keep pushing, and then when you reach a brick wall, you're actually set up nicely for disability retirement.
Is there a financial or strategic advantage to filing earlier rather than later?
If you qualified earlier and then you apply later, then there is not a financial advantage because you're going to get a back paycheck, though it's going to take a long time. And we talked about that in the previous podcast. So you're going to have to be prepared to be without money for a while, but in the end, you should be made whole. So there is no financial disadvantage there. But let's say you're really trying to stay in your agency, which I commend and I respect very much. And you spend 2 to 3 years going back and forth within the reasonable accommodation. So technically you're making more money because you make more money when you're working than you do on disability retirement. So I would just say financially, no, there's no advantage to doing it early rather than later. Strategically just depends on the truth. I always like to say, don't let the tail wag the dog. Apply for disability when you really need disability, but don't be scared to do it if you really need it. That's when you may be leaving money on the table, I guess, in a situation where you could have gotten disability retirement, and let's say you move on to leave. And so if you don't get disability retirement, you won't get that leave paid back to you. So that's a little bit nuanced area that doesn't happen that often. The final answer I would just say like this is financial or strategic, whatever it is, at the end of the day, what matters is when you need disability benefits, you need to apply for them because it takes you or our agency, if we help you, at least 2 to 3 months to get the application together, and for your agency is involved in that process too, and they take a while. And then it takes OPM about 9 months. So the sooner you do it, the quicker you get money in your pocket.
And how do you help a client assess whether to stay and fight or to start the retirement process?
I usually ask them to go to their gut and tell me what they really want. Do they feel they're disabled and they just can't keep working? Or do they love their job? I usually say, is your job your dream job? Do you really enjoy it? Should we spend time trying to really push for that accommodation? Ironically, sometimes it's the latter, what I just mentioned, but the agency doesn't care and they don't accommodate you, and you end up having two things going. You end up having an EEOC case for reasonable accommodation going at the same time that you have OPM. And I make sure that you do that because that way you can't lose. Because if you win your reasonable accommodation case, well, you get the accommodation, you usually get your attorney's fees back. If you want reasonable accommodation, and there's a chance the agency still is never going to accommodate you and you want to fight your case, I still want you to apply for disability retirement, because if we lose your case and you get fired because you can't do your job anymore, at least you have OPM disability as a safety net is the best way. That's where I was heading with that.
So this is a double question. You've already answered this throughout the episode, but can an employee simultaneously pursue accommodations and file for OPM disability?
Yes, that's exactly following perfectly on the heels of what I just said. Not only can they, many times they should. However, this is one of why I usually do case reviews with clients, is because it's super confusing, because it seems like you're doing things that are at cross purposes, and you really are. And when you apply for disability, you're saying, I can't do any job with or without an accommodation for the federal government. Not that I can't do any job, that's Social Security, but I can't do my job with or without an accommodation. At the same time, when you say reasonable accommodation, you have to, in order to be protected by the laws called the Rehabilitation Act, which is the ADA, or Americans with Disability Act for federal employees. In order to qualify under that law, you have to be a qualified employee, the law says. And to be a qualified employee, you must be able to do the essential functions of your job with or without an accommodation. So on one hand, you're saying, I can do my job with an accommodation. For disability, you're saying, I can't do my job even with accommodation. So a person might be like, well, now I'm a hypocrite, or I'm going to lose. So the answer to that, I usually tell them, is, look, you believe you can do your job with an accommodation, but the agency doesn't. So if they're right, then you should get disability. If they're wrong, you'll win your case, and you didn't really need disability. And better to lose, let's say you paid an attorney a few $1,000s on the attorney, but be able to work in your dream job forever, or maybe even be able to win your reasonable accommodation and get paid back the money. Generally, you can't get paid back for disability retirement, but you can get paid back for any amount of money you paid the attorney as it relates to the EEO case.
And what role would documentation play in making a strong disability case?
Well, documentation is the essence of any disability accommodation, because the OPM clerk doesn't meet you, see you, interview you, give you a fitness for duty test. They're basing everything on paper documentation. So there's two things that I highly recommend as far as medical, was what we're talking about here. Is number one, get a great letter from your doctor that speaks specifically to the fact that you cannot do your job. They call it useful and efficient service, or you can call it the essential functions of your job is another way of saying that. So we as a firm, that's what makes us unique. We draft that letter for your doctor. Of course, we always get permission from the doctor first, and we will not take you on as a client if your doctor will not support you and use our letter as a template. Of course, we don't want to put any words in the doctor's mouth, but we lay out basically a whole template for what your doctor should follow. What OPM is looking for is that really sometimes they take it wholesale, and of course they make sure everything in there is ethical and accurate, but sometimes they take it wholesale and sign it with those small changes, and sometimes they use it as a template and rewrite it. But so to answer your question is, we find that to be essential, something that speaks specifically to the requirements for OPM disability and talks about you and your position description. So that's number one. That you for sure need to have, ideally from a lawyer, but if not, at least you should look up what the requirements are. Make sure your doctor speaks to them. And then the other part of the answer to that question is that that if you have medical records that support your disability that have nothing to do with being a doctor's letter written by us, that helps as well. And we also assist with helping you gather that and put that together in a clean package.
There are a lot of details in this episode. Someone can pause and go back and listen, but how could a legal representation help someone navigate all of this transition pretty smoothly?
So I think that was pretty much what I was just saying. I want to point out that you don't need a lawyer to do pretty much anything on this call. In fact, the interesting thing is this area of law doesn't even require lawyers. It requires somebody who just knows the law because it's federal administrative law. But at the end of the day, the things, if you listen to this podcast, and if you got this far and you're still awake, I'm impressed. Just kidding. But if you listen to this podcast and you felt like there was a lot in here you would not have intuitively known yourself, well, that's when having someone with the expertise, like we've done it for close to 25 years, as I think I said on this podcast or the previous one. We've created systems. We know what OPM's looking for. We have probably about 150 this year. I think we have like 250 applications that we processed. And pretty much everything we've turned in, even though it might have taken an appeal or two, has gotten through. I think we have maybe one denial out of the couple thousand we've done, ultimate denial. So at the end of the day, look, it's you can do it yourself. I don't want to say that you can't, but the amount of money and difference it'll make over your lifetime, and the stakes that we're talking about. I like to tell people, as I said earlier, it really could be millions of dollars over your lifetime. And if you include your retirement benefits and you live to be 100, 120, I mean, it could be a couple $1 million worth of benefits over your lifetime. So like what's, $6,000, $7,000, $5,000, whatever the lawyer's going to charge you, it pales in comparison to the changes over your life. And that's not something that's intuitive. Like if I was thinking of like, should I get myself an attorney for something? I'm not generally thinking about the difference it can make over your lifetime. But if you sit down and you think about it, it really is like the money, some of the best spent money possible, in my opinion. But I'm biased, so there you go.
Well, thank you for sharing everything with us today. And thank you everyone for joining us on Empowering Workers. If you're at a crossroads between accommodations and retirement, get the guidance you need at pinesfederal.com. And don't forget to leave a review, and subscribe so you never miss an episode. Thanks again.
Thank you, Chelsea. Great to talk to you as always.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.